Welcome, everyone, to the first in a series of webinars celebrating JURIST's 30th anniversary. Before we begin, I'd like to turn things over to Professor Bernard Hibbets, JURIST's founder and publisher emeritus, to say a few words by way of introduction.
Great, thank you, Jackie, and it's good to be here, and it's great to see some familiar faces on this Zoom session today. It really is extraordinary to consider that 30 years ago, almost to the day, actually, JURIST was just a couple of lines of HTML code that I was typing out in an office at the University of Pittsburgh Law School. It's a little bit different now. Things have changed, and now we are part of a global network which engages students from around the world who are reporting the rule of law in crisis. And I am pleased that we are marking this occasion by a series of webinars that we will be hosting over the next several months. Several speakers are already confirmed. There will be more to come. We're looking forward to having our speakers address various aspects of the challenges that the rule of law is facing around the world in various ways, in various capacities, in various jurisdictions. But for now, I just want to say welcome. Thank you all for being here, and I'm going to get out of the way so that Jackie can introduce our speaker, because I'm very much looking forward to hearing his remarks today. So thank you all again. Thank you, Jackie.
Thank you. It's now my pleasure to introduce today's speaker. Robert McCorquodale is a member of the United Nations Working Group on Business and Human Rights, which is a 5-member body of independent experts. He is Australian and serves as Emeritus Professor of International Law and Human Rights at the University of Nottingham. He is also a former barrister at Brick Court Chambers in London. Professor McCorquodale has more than 30 years of experience in business and human rights. He has published extensively in the field, including empirical research, and has advised businesses of all sizes while assisting governments and civil society organizations around the world. His work has included capacity building, legislative development and training, as well as field research and qualitative interviewing. He has appeared as an advocate before both the International Court of Justice and the United Kingdom Supreme Court. So with that, I will turn things over to you, Robert.
Thank you very much, Jackie, and a particular honor it is to be here, part of the celebration of 30 years of the extraordinary thing that JURIST has become. And many, many congratulations to you, Professor Hibbets, for what you've done, and that you should have thousands of students who you've helped and mentored into assisting so many of us around the world in all that JURIST provides. And I also want to thank the Board of Directors for, particularly Anna and Stevenson, for suggesting that I be one of those who are part of this 30th anniversary celebration. The context of why I've chosen this topic is that, of course, to some extent, the whole role of business challenges the idea of a rule of law. Rule of law, in an international scene, we tend to think it's all about states. So I'm going to just start with a slide which talks about where we were and then quickly move into where we've become. So, Jackie, if you don't mind going to the next slide. This is the traditional approach to international human rights law. Many of us will have heard that, and probably many of us have been taught this, that basically international human rights law is about state actions in relation to individuals. And particularly what it means is the state is the actor with responsibility. So let me look at that in two ways. Firstly, Article 1 of the Convention of the Rights Against Torture says that torture has to be, and I've highlighted, by a public official or other person acting in an official capacity. So if you are unfortunate enough to be grabbed by somebody, begins pulling out your fingernails or whatever, it may feel like torture. It may really absolutely be horrendous to your health and to your body. But if that person is not a public official or a person acting in official capacity, under international human rights law, that is not torture. Why? Because you've been chosen by the wrong perpetrator. So that's the very narrow view of what international human rights law and international law generally would look at. The second part of it is, then who has responsibility? It is only the state. And so in this example I take from the African Commission on Human and People's Rights, there are massive damage by oil companies to parts of Nigeria, goes before the African Commission of Human Rights, and they say, well, Nigerian government, it gave the green light to private actors, and they, the oil companies, did this devastating thing, but it's actually only Nigeria we will find it to have responsibility. Why? Because that's how the normal traditional framework of international human rights law is. So with that in mind, let me jump to what has now changed. Since 2011, the UN Guiding Principle of Business Human Rights shook that foundation up. I'd like to say it began before, but it got to its kind of clear standard with this. That set out 3 pillars. Firstly, it repeated this idea that the state has a duty to protect human rights. No challenge in that. But it suddenly says business enterprises, they have a responsibility to respect human rights. So those oil companies in Nigeria, they have a responsibility. And there needs to be an effective access to remedy. Now, this isn't a treaty. This isn't some kind of extraordinary, what we might call hard law, but it's authoritative. It is absolutely the basis for where we now see legal practice, we now see legislation, we now see a whole lot of actions that have happened. So Jackie, if we could just move to the next slide. You might need to click again. Thanks. So why is this influential? Well, because from this, a number of actions have happened. Firstly, the OECD guidelines, which is the guidelines for the developed countries, they have guidelines for multinational enterprises, and that basically completely picks up the UN Guiding Principles and make it a legal responsibility for states who are part of this developed world that they should have these guidance and put into action. Secondly, IFC, that's part of the sort of International Finance Corporation, part of the kind of World Bank group of financial bodies. They have performance standards based on this. The Equator Principles, which are for banks and other financial institutions, they have these guiding principles. And the International Labour Organization, as part of their principles, they also have it. So it's already seeked across a range of different sectors and ideas and countries. And then it falls into legislation and business practice, as I'll show. So although it is only a guidance, it is nevertheless enormously influential. So if we could go to the next slide, please, Jackie. So let me look at the first part briefly, the state duty to protect human rights. Basically what Guiding Principle 1 says, the state must, and it's one of the very few statements in the whole Guiding Principles, which is a must. It's a clear statement. The states must do this. They must prevent, investigate, punish, and redress, and have effective policies, etc. Now that is basically restating existing international obligations. And I flag the fact that it's not only some human rights, it's all human rights. So although, for example, some states only have legislation on, for example, modern slavery or on forced labor, in fact, this is an international obligation on all states about all human rights. It also includes both states and non-state actors where the state has a responsibility for them. So, for example, a state-owned enterprise, and it's their acts and omissions. You're meant to put in place various policies which are coherent. And who is the business which the state is meant to have this responsibility? It is for businesses in what's often known as their domicile. Now, for US or other kind of industrialized states, the normal thing is where the business is incorporated. But it could also be where its central administration is, which might be separately, because very often businesses incorporate, say, in a zone which might be tax-free or whatever, or their principal place of business. So if they're operating, let's say, in Canada, but actually they're incorporated in Liberia, it can be Canada that still has this responsibility for their for the business enterprise. And the other astonishing thing here is it's even when businesses are acting elsewhere. It's a constant theme in international or international human rights law is what about extraterritorial aspects? What if the state acts extraterritorially? In other words, acts in another location, such as Rwanda did in the Democratic Republic of Congo. What's interesting here is it is the state's responsibility for a business, even when that business is acting what I prefer to call transnationally. So, for example, if this Canadian business is operating in Uganda and That's part of one of its subsidiaries. The Canadian government can have this responsibility to make sure that that business responds to the Canadian law about, let's say, its modern slavery actions elsewhere. So it is quite transformative in saying, listen, this law is not, yes, it's going to be only the law in Canada in that instance, but it can be for what business activities happen outside Canada. So that just gives you this context in which, yes, it's the existing legal obligations, but they've been moved a little bit further along. So that's the starting point. Can I have the next slide, please, Jackie? Now, this one I'm probably most proud of all the slides because it's taken ages to create and I hope it makes some sense. So this is the current business and human rights regulatory framework. And you think about, this is really only since 2011, most of this, and it's gone extraordinarily wide. So, for example, in the European Union, which is in your top, well, my top right, where that it features in your screen, there's conflict minerals regulation, there's corporate sustainability reporting directive, there's also the corporate sustainability due diligence directive, which has just been sort of revised by the omnibus, which puts on mandatory human rights due diligence obligations on certain companies. It's also in France, there's a corporate duty of vigilance law. I mentioned Canada already, they have Modern Slavery Act. In the USA, because there's a Uyghur Forced Labor Prevention Act, there's a whole there's the Californian acts in this kind of area. But elsewhere, mainly, of course, in the industrialized world, but not only. Sierra Leone has groundbreaking law in some of this area, as does Brazil and as does South Africa. So there's a whole range of laws which are coming out of this understanding that states have a duty to protect human rights in relation to business activities, and therefore there's law about what businesses can and can't do. And so we move to what's the corporate responsibility. Well, it's basically twofold. Firstly, they must avoid causing or contributing to adverse human rights impact in their own activities, and they have to seek to prevent or mitigate adverse human rights impacts by business relationships. So let's say down their supply chain or to a business in which they're engaging in some ways. So they're two very clear rules. Don't cause or contribute and prevent or mitigate in a business relationship. Now, what do they need to do? Well, effectively, they need to create what's called human rights due diligence. I'm going to explain that a bit more in a second. But basically, it's you have to assess, integrate, act on, track, and communicate about what you're doing. And it should cover impacts which the business is doing, but also where it doesn't matter whether it's the size of the business or the risk or the nature, and it's not a one-off. And I'll explain that in a moment. If we could go to the next slide, please, Jackie. So what does this mean? Well, the starting point is it means it's all business enterprises. It's not just some. It can be even your shop maybe down the corner that you bought coffee from this morning. It's even them. Why? Because they could have maybe child labor in there who's working there, or maybe the cups of coffee, for example, could be have some real issues of environmental damage by their use. So it's all business enterprises and it's all human rights, not just some. You kind of think, well, how is a business going to affect, I don't know, issues of education? Well, as a lot of things become privatized, of course they can affect education. Of course they can affect a whole range of security issues. So businesses are in so many parts of engagement that all human rights could be affected by business activities. And I already said it's about cause, contribute, or prevent or mitigate. But also many instances, a business has powerful positions, often more powerful than states, so they can leverage, have pressure to make changes in that. And maybe the key thing, which is often forgotten, due diligence is a term we often use about business. This is human rights due diligence. And that changes the focus. Instead of the focus being what are business risks, it's what are the risks to the rights holder? What are the risks to the victims? Which the business then has its consequence actions, for which then the business has risk. So it might well be the community which is being, its land is being destroyed by the business, say cutting away the timber or whatever which supported, or polluting their water. So the focus is their rights, their risk, and then the business needs to take action. And it's not a one-off. Normal due diligence, you do a one-off, what's our risk? We're buying this company or whatever, that's our risk. This is saying, nope, that is a continuing responsibility. And regularly you are checking what it is. And maybe the toughest one in all this, and businesses struggle with this, it's a responsibility that exists independently of what the state is. So simply complying with a state law doesn't get a corporation out of this. Why is that? I can give you an example. There's a country in Asia which had a provision that any business employing women should force them to undertake a pregnancy test. Now, that's an extraordinary breach of their rights. And if a business just simply complied with that and said, well, we don't need to have those worries, they would be rightly condemned, because it's an expectation that the business responsibility is independent of what the state is doing. And so it does make quite a significant problem. I mean, I engaged with a company that was working in apartheid South Africa, and they still said, well, of course you won't employ any senior black people because that would be contrary to apartheid. And I said, but you're still abusing human rights. You are complicit in this system. You have a higher responsibility. Okay, so that's the kind of extraordinary thing we're talking about here about corporate responsibility. We could go to the next slide, please, Jackie. And the key of this is this thing called human rights due diligence. I've explained its context. It basically has 6 elements. The starting point, which is in the middle of that slide, is to embed it into policies and management systems. So it's throughout your operations. It doesn't just end up a headquarters tick box. And then what you have to do when you go to number 2 is identify it. And the trick is not identifying in advance. I worked, for example, with a telecommunications company, and they said, we know what our human rights risks are. They're about freedom of expression and about security of your material. I said, that's great. But what about when you put a cable across a whole lot of land and you push everybody off their own land in order to dig your cable in? Never thought of that as a risk. So thinking, what could be your adverse human rights impacts? Thinking of a human rights impact assessment, which you do before you make decisions. And you can prioritize. You can say, no, this is a more severe human rights risk. We will deal with that first. Because business, just like governments, they don't get it right all the time. It's not meant to be a perfect thing. You're meant to be taking your way on assessment, on a kind of move forward on this. And then you try and cease, prevent, or mitigate. So it doesn't always need to be cease, those adverse human rights impacts. You then track it. It's not just stop there. What is happening? What are we finding out? What do we need to do? And then communicate. And that can be hard for lawyers, communicating about the risks. But it's interesting, I've spoken to lawyers in a number of the big firms, and they said, actually, sometimes it helps us to be open and honest about this because it helps internally, but sometimes it helps and has been used. I can give a specific example. Nestle had a case brought against them in California, and they said, listen, this is what we've done. This is what we publicly stated. We are still not getting it right, but we are trying to get it right. And actually, they won that case. And finally, in the last point, number 6 there, in appropriate cases, remediation. Remediation doesn't always need to be in financial terms, but I'll come to that when we get to it. So that's this core element of this corporate responsibility to respect human rights. Next slide, please, Jackie. Now, I love cartoons. So I have a cartoon there. And for those who can't read it, it's this sort of CEO being told, talking to the doctor and saying, lately I've been feeling ethical. Can you prescribe something for that? Now, that's probably what a lot of us might be thinking. This is how companies all operate. And you think, well, they're actually deeply cynical. They're not really interested in being ethical, and they want to just slide past getting any advice on this. That is not necessarily my experience. And I can tell this from research I did. And if you go to the next slide, Jackie, this is research I did together with a number of much more brilliant people than me, looking at actually, do we introduce a European Union regulation on human rights due diligence? And we asked 361 businesses, and this is the responses. If you look at the columns, over 70% of businesses said yes. Actually, we do want this kind of regulation. And a lot of the other stakeholders were even more in favour of that. But businesses were wildly in favour. It was actually, I think, 76 point something %. Yes, we want this. Now, why do they want this? Well, if you can see the kind of steps below, they actually want a harmonised level. They want to know what they're meant to be doing. They want to level the playing field so we all know what everyone else is doing. They want legal certainty. There's always a law in there somewhere. And it helps in their negotiations, in their value chain, in their supply chain, their production chain, to say this is what we need to do. And it's a competitive thing. I mean, I've spoken to many companies who say, actually, we are trying not to, let's say, have child labour in our supply chain. And then our competitor their costs go down. Actually, that's not fair. And you end up encouraging child labour as a cost reduction. So actually, companies, when you ask them, a surprising number actually want this. They want this clear regulation so they know what they're operating on. So it's not always the cartoon I showed. Jackie, next slide, please. And the last element, often forgotten, is access to remedy. And it's both for states. They have and here's the word must again, they must ensure there is some kind of effective remedy. And it's also about companies having their remedy. And so it's good, effective judicial mechanisms without barriers to access. And that's hard across the world, I can tell you. I've worked with many victims where actually it's very hard to be able to access, obviously, firstly in their own country. So they're usually going somewhere else to maybe the headquarters of the company. Trying to fight their way through that legal system is extremely hard, particularly when most of these issues don't have a human rights cause of action. It's possibly going to be a negligence or a environmental, or the human rights may not always be the language of the case. Having non-judicial remedies, including remedies on what's called an operational grievance mechanism, where a company puts in place some kind of mechanism, particularly for their workers, particularly for the local community, which enable issues to be raised. And in my experience, and I've been a mediator in this area for a while, actually often that's where it all gets resolved, much better than 12, 13 years later. I've been in cases where it's been 12 years before it even gets to be looked at by a court. And often that's not done sufficiently. And there's a sense to which particularly vulnerable and marginalised groups need to be aware of this. Just want to add one point. The commentary to the Guiding Principles 25 says all these different kinds of remedies, and that's important. The other thing I would add is it should be a remedy to the rights holder. It's very tempting to give a fine to a business, let's say for polluting water, which means the people in the local area can't grow crops or can't fish or whatever. But that's not a remedy to the rights holder. A fine to a business goes to the state. It doesn't give a remedy to the rights holder. So just being aware that that's an element which I don't think has been picked up enough. So Jackie, I just wanted to then, if you could go to the next slide, please, just look at some instances where there have been cases. And I know it's one of the wonderful things of JURIST is picking out some of these cases. You'd be pleased to know I'm not going to go through all of them, but just to give a flavour for them, and I have to declare that I've been involved as a litigator in some of these cases. So the Vedanta case was really the first time any senior court anywhere in the world said, yes, a parent company has a responsibility to those who its subsidiary has been causing human rights damage. In that case, a copper mine in Zambia polluting the whole area where there were farmers and others. So they're saying that we have to be very careful when we think of a duty of care of a company. It can extend further, this idea of transnational I mentioned before, than just where we think the narrow limitations are. In the Milieu de Foncy case against Shell, they said, and that can extend to climate change issues. In the end, that was overturned on appeal, but not the basic element of the climate. It can extend to climate change impacts, particularly where, in that case, Shell had said, we are doing well on climate change. It's extended to arbitration tribunals on investment. Perhaps an interesting case is the Nevson and Aria case before the Canadian Supreme Court, where here was a case where a company was working hand in hand with the Eritrean government. And they thought, well, as I talked about before, this is the law. We're simply following what the Eritrean government is doing. And in that instance, the Eritrean government were providing them with their main employees. They didn't ask once, where did these employees come from? And they were all forced labour, all of them. They'd never checked. So the Canadian Supreme Court said, you, Nevson, are responsible for this. In fact, they even suggested we don't even need to sort of look at special tort law for this. We can just say there's international law here for which a business should be taking responsibility. But it was quite an interesting issue where the company couldn't hide behind the fact that the state was involved in it. More and more cases. Oh, sorry. Can we just pop back? There's more and more cases against financial institutions. The one which I've got there, Equitable Cambodia IDI against ANZ, Australia and New Zealand Bank. He's one of the biggest banks in Australia, and they put an investment in a company without checking for one moment what that company was going to do with that investment. And the way they used the investment was to destroy lives and others in that was a sugar industry. And finally, there's now a range of cases where, in fact, individuals, CEOs, chairs of boards have been found to be responsible where they haven't understood the human rights risk which companies have been involved in. Given one example, Anesis and Nexa, that was where a software company provided a whole lot of software to the Libyan government, made a huge profit. This is fantastic. Didn't check what are the Libyan government going to do about this. And of course, it was in Gaddafi's time. He used it to basically infiltrate and murder a whole lot of innocent people in this context. So there is this responsibility which is building. Okay, if we can just jump to the next slide. I have to, of course, mention the work I'm involved in, which is this working group on business human rights, of which there are 5 experts, independent experts. We're not UN employees. We're part-time and try and do this when we can. A bit like Professor Hibbert's and the work he does. That what our role is a range of things. One of which is we do have a remedies role. As you can see, we've done over 1,100 communications, which is a polite word in the UN for complaints. And we can, if someone writes to us with a concern about a particular issue, we can deal with it. And we aren't a judicial body, but we are a public body, and we publicise what our concerns are, and it can lead to action. We've done a variety of communications and press releases about it, for which there has been consequent action. We also do country visits. We go and do a deep dive into countries. We went to the US, we've been to Canada, we've been to a range of different industrialized countries. And I was in Serbia a few months ago. We're in Japan before that. We're in Argentina. We go around the world and do this deep dive. We also produce reports. I did led a report that we shared around. I led a report last year on the finance sector and their responsibility. Got a report coming up this year last year, which we had on artificial intelligence. How's that being used by companies? Not the metas, but how is an ordinary company using their artificial intelligence? And this year, for example, we're doing one on agribusiness and we're doing one on corporate governance. And then we have annual forums. Any of you been, we have these annual forums in Geneva. Last year had almost 5,000 people attending, which if you think when I first started this 30 years ago, there were barely a handful of people. It's extraordinary, that kind of level of interest. Obviously, some of which are academics, some of which are students, many of which are companies and civil society. So that's the context of what we do. You can move on from that, Jackie. I just wanted to flag, there is something else which you've possibly heard of, which is this idea of a business and human rights treaty. It's not run by us, the working group. It doesn't have a explicit role in this. But that's another way where the UN guiding principles could become sort of hard law. To some extent, some would say it's not needed because it's already having this influence. But I just thought I'd flag this so you're aware of it. It's been going a lot of years, since 2014, and we're still just beginning to negotiate some various elements of it. So I think it's still quite a way to go. I'll move on from that. I just thought I'd flag it. So I just wanted to come back to, how I began by saying this is the traditional international human rights law. Well, in fact, what we're seeing is the whole idea of international human rights law, international law, the rule of law in an international context being about states and individuals gets really challenged by business and human rights, but by the general increase in the corporation's role in international affairs. We see this with international economic law, where corporations have the right and can bring claims against states. I mean, that's an extraordinary thing if you think about where the international law began, because some would argue, yeah, but states still have to consent to it. But less and less power do states have to resist that. If a company is investing in your country and they say, yes, but we're not going to be subject to your law for a dispute, we have to be subject to international, as a government, you don't have much power to prevent that. So that's one area. The second area is international environmental law, which has taken off as the idea that environment is not just stuck to a boundary. Issues of the environment sometimes created. In fact, one of the most famous cases is a case on the border between Canada and the US, transboundary pollution, and the Trail Smelter case. And so way back at one of the earlier stages of international, they were recognizing things like environment don't suddenly stop at a boundary, a state boundary. They're transnational, and that there are obligations both on states and corporations. And then most powerfully, in the last year, there's a decision by both the International Court of Justice and the Inter-American Court of Human Rights about climate change. And I've got the Inter-American Court one here just because it was a quicker way of picking it up. But the International Court of Justice made it clear states had these obligations, and part of it was to prevent activity by the businesses, which of course is the guiding principles already said. But what's important, the Inter-American Court said, remembering this is also a legal obligation on private individuals, including business enterprises. So climate change is not just, once again, like many people suppose, just an obligation on states. So this is beginning to show how business and human rights is part of a broader challenge to this kind of rigid international law, international human rights law approach to what is law, but also what is the rule of law. We could take the next slide, please, Jackie. So as I said, it challenges this idea of state sovereignty and state-based international law. And what's extraordinary is states are accepting this. And businesses accept that they should be doing that, they can have rights, they can have responsibilities. Courts are beginning to apply it, as I've shown you with the Inter-American Court, for example, and the International Court of Justice. And in fact, it's not necessarily as new as we think it is. Penelope Simon in a wonderful article shows, well, actually way back, that was what was happening too. There are many kind of corporate entities, such as the British East India Company, which effectively went into India as a company. They ran an army, they ran sort of whole estates. This is not new. And that in a sense, a lot of the international system, in trade, in investment, etc., has been with this underlying aspect of that companies are part of this process. And so when we think about who is involved in this international legal system, we have to begin accepting that companies are heavily involved. It's not just about state action. And I think that is a challenge too, but also, as we see in business and human rights as a field, an opportunity for the international legal system to begin recognizing these major players are challenging this idea of a state-based, a state sovereignty international system. And it's no longer just about what states consent to or not. It goes beyond that. So let me then flip that on to where it fits with the rule of law. I love the rule of law. I think, though, we sometimes use it as kind of trip off our tongue without recognizing actually it's enormously powerful. It's saying everybody within a state and an international outside this is part of this being bound by the benefit of laws. And it's not about just rule of law. It's about rule by law. So, for example, and here's a very helpful definition by the Venice Commission. It's not just about a formalistic concept that if a public official, come back to that term, if a public official is authorized by what legislation says, then that's enough. It's much more than that. You cannot just say authoritarian action by governments because they've got law behind them, just like Hitler did, just like a lot of the authoritarian rulers. That is not rule of law, that's rule by law. And what's interesting is it avoids then the human rights elements. But rule of law includes this idea that human rights are part of it. And in fact, as Tom Bingham says, we do need that rule of law in the international affairs, which include human rights, or the lovely term that JURIST uses, situations of crisis. Because in crisis is exactly when we need to have a rule of law. Because if we simply say the law is what it is, we often cannot take any action on this. So let me then just finish with this last slide. What does this mean for us as lawyers? And I'm assuming most of the people, though not everybody using JURIST will be lawyers. First means, of course, law firms, they're business enterprises. So they have this responsibility to respect human rights. When I tell them this most of the time, they're like, oh no, we're advising companies. Like, yeah, but you're a business enterprise. So it can be a bit of a challenge to them. But there are legal and commercial risks to companies which lawyers, which us in the legal sector need to be alert to. We only need to open the newspapers and we'll find there are a whole range of issues where the human rights does create a legal and a commercial risk, particularly in the context where my understanding is a lot of the CEOs of large businesses, particularly in the US and elsewhere, have resigned for reasons which are ethical more than financial. It perhaps indicates where this is moving. And that we have to be wary of mere compliance. It's just like I talked about before, simply complying with the law may not be enough to be still consistent with the responsibility to respect human rights. And we often see that in reporting. In fact, I've been in a case where a company had reported that they'd done wonderful things. And then in the case, it was shown they were definitely not doing wonderful things. And they tried to dismiss this report by saying, oh, that's just public affairs. That's just a press release. I'm sorry, a report these days is nevertheless evidence of what companies is doing. And they have to be doing it, not just saying they're doing it. And then I want to look at these last two elements, knowledge and awareness of developments, because this is a fast-moving area. Okay, I've been doing it 30 years, but the reality is only since 2011 this has really taken off. It's in court cases, it's in legislation, it's in a whole range of different sectors and ideas and contexts, and that the knowledge and awareness of developments is crucial. And that's where jurists come in, because jurists provides that news that enables us to know what's going on. Because without that, so often lawyers, businesses are not aware of these situations, which actually creates risks for them as well as risks for us and risks to the rule of law. So that's my kind of context of why not only does jurists matter, but why thinking about international law, thinking about law in crisis covers much more than just what governments do. It also covers what businesses do. Thank you. I think that was almost exactly on the time you gave me there, Jackie.
All right, thank you very much. And yes, I wanted to make sure that we left some time for questions. So feel free to type a question in the chat or raise your hand and we'll call on you. And looks like David Crane has a question.
Well, thank you so much. And really, you lay out really a wonderful overview of state of affairs and really the hard work that's being done in the background that's really not noticed in some ways in our profession, but yet is critical. Having been a chief prosecutor of an international war crimes tribunal in West Africa, I was constantly faced with the involvement of businesses in war crimes and crimes against humanity. So I approach it slightly different than you, Robert, but slightly the same motive and the same perspective, and that is rule of law. And the question has always been, can a corporation commit a war crime? And I think that jurisprudence is beginning to move in the correct direction. But in West Africa, in 2002, I was immediately aware of and made aware of the incredible involvement of the De Beers Mining Corporation in extracting diamonds out of West Africa, and particularly Sierra Leone, which were alluvial diamonds. In other words, they leach to the surface and they're only 10 feet below the surface, and you get gem quality diamonds. I contemplated the potential of indicting De Beers Mining Corporation for international crimes. But I chose not to because, it's like tobacco litigation back in the 60s. You have to have the right case because you can't lose the case. It sets bad precedent. So I didn't have the jurisprudence, frankly, to really support my case against the De Beers Mining Corporation, even though here's a good news story. We were very much involved, and we found a Dutch business headed by Gus Koyhaven from the Netherlands, who was very much involved in guns, diamonds, and et cetera. And we referred the case to Dutch authorities, and they went forward. And he was convicted at the trial level, but at the appellate level, as you probably know, Robert, he kind of was not exonerated, but the jurisprudence was weak, and it was not an effective final judgment, but it was an attempt. And of course, we all know at Nuremberg, we tried to go after the Krupps, and that was one of the acquittals at Nuremberg was the Krupp Corporation. So we're still, from an international criminal law point of view, we're still kind of stumbling forward, but yet with Ukraine and Gaza, but particularly Ukraine, with all kinds of aiding and abetting aggression and corporations very much involved in providing materials, particularly to Russia, which are perpetrating an act of aggression, they are certainly setting themselves up for potential criminal liability. So I just, as a point of law, but again, listening to you and the movements forward, I was just very much reminded that on my other side of the coin, we're still stumbling, but stumbling forward. I mean, there is a beginning of a beginning here that we'll see potentially corporations being held or being prosecuted for international crimes.
Thanks, David. It's brilliant to get your kind of perception and your experience on this, because I think you're right. Had you tried De Beers at that time, there just wasn't the basis to be able to bring the kind of cases that then have been brought. And at the moment, there's a big case in Sweden against Luden and a case in France against Holcim, both where the Holcim case, for example, the company basically wanted to keep its cement operations running in Syria. They negotiated with ISIS at the time to enable that to happen. And of course, then it's moved forward and said, listen, they are complicit in a war crime. And they've been held that a charge can be brought. The case is ongoing. But as you know, it's incredibly difficult, even in a situation where you're dealing with leaders of countries, to always find them to be guilty of war crimes. So it's incremental, but I think with things like the UN Guiding Principles, it begins to slightly change the conversation, and I think that helps, so that it's now not so. Now I hope for, let's say, a company like Holcim, but not Holcim, they will begin to think twice in Ukraine, in Russia, in sort of Sudan. Think twice before they just happily kind of negotiate with those involved within a war. So thank you. It's great to have your kind of take on this.
Well, it's interesting. I was just saying, if I had this kind of structure that you are now currently working in back in 2002, 2003, that could have allowed me to compare and contrast, saying there is law in this area, and it would potentially have given me a cornerstone, perhaps, to go after De Beers for what they did in West Africa. But it was very tenuous. So anyway, but thank you. This has been a very interesting presentation.
Thank you.
Other questions? Alexandra.
Hi, thank you so much for coming on this and having a talk with us. I'm really interested in this area, and I wanted to ask if you had any like future projections for the area of international business development, and just kind of like what a future look would be.
Wow, that's always a hard question. I'm notoriously terrible at these things. I'll break it up into a couple of different points. I think starting wise, just in terms of job opportunities, when I started on this kind of area, as I said, 30 years ago, you couldn't get a job working in this field. Nowadays, as I say, almost 5,000 people attending this major conference in Geneva once a year. That shows that actually work in this field is exploding. Working, yes, with businesses. Businesses now have jobs such as human rights director or sustainability manager or corporate responsibility engagement. Those didn't exist in the way we now understand them too. I'm still concerned that not enough of them are senior enough to make a difference. But it means that in business, they're beginning to respect there's a need for this kind of area. In government too, I mean, there are whole developments in across the world in government kind of areas. I showed you that map of the world where in so many circumstances there's development. Of course, there's pushback. I don't pretend. I'm aware, obviously, of some developments in the US which are pushing back against this. But the surprising thing is how many companies are still moving forward, despite what may sometimes be legislative pushback. There's development, and there's a whole lot of international organizations, a whole lot of not-for-profits which are working in this in a very effective way. And that's one of the great things about this university, is that, of course, it does encourage thinking beyond the kind of corporate field. But even in corporate fields, there's a organization called the Business and Human Rights Lawyers Association, which are lawyers working in the corporate field, major companies, recognizing they need to engage with companies on this. So that's one area where things have developed. Let me come back to your kind of sort of what it means in terms of topics and subjects. I would say what artificial intelligence technology will definitely have an impact, positive and negative. So, for example, a lot of these issues are what are often seen down the supply chain. There are technologies such as what's called blockchain, where technologically you can find out where did that actual product, let's say the coffee cup you're holding, where does that actually begin? And you can begin finding out because technology enables that. Technology can also enable surveillance, which can be good and bad, of course, in its two forms of action. But there's a whole range which technology can advance. But there's also dangers in that technology where it's used without thinking, what are the consequences? And I can give you an example of this. When we did this report on artificial intelligence, time and time again, companies just grabbed the software, thrust it in their system, weren't at all aware that maybe in doing that, certain groups were excluded without a person with disabilities, for example, couldn't access some of those kind of elements that are now in the business. So that's one area, is technology. The second area, I think, where developments will happen is that areas such as environment, climate change, which have traditionally not been central to human rights, will be seen as actually also part of this kind of discussion and development, because companies make big impacts. And often it's, I mean, I gave you a couple of cases, both of which actually the main issue was environmental damage, which caused then human rights consequences. I also think some of the areas where there will be change will be thinking not just of the supply chain, but of where you're selling a product to. Let's say, and I'll pick up David's example, let's say we have a product which is being sold to Russia, which is then going to be used in Ukraine. Actually, that company has a responsibility. We're not always thinking of that. We're only thinking, well, what's happening down our supply chain? But what happens if, I don't know, it could be a tractor that they're selling, but it doesn't take much knowledge these days or technology to find out where's that tractor going. And more technology actually will be on that tractor, which they will know that's where the tractor is and what it's being used for. So I think that's both technology and also use in this area. I also think there are going to be developments in legal redress, that at the moment it's very, very hard to bring claims. If you are a person in the middle of a forest which is being torn down, very hard to bring that action. But I think that is getting easier, and I think there'll be an increase in number of people who will be able to assist those who are affected by it. So I think there'll be a range of different actions. And the final element, I think, is actually other sectors. the accounting sector will begin to say, well, what are actually the real assets which are being undermined when a company begins digging up the gold or whatever, and what are really actually should we be thinking about this? There'll be audits which companies are meant to go through, which will, lawyers will say, listen, that audit, wasn't helpful. I can give an example. In Bangladesh, in a place called Rana Plaza, there'd been one which is a lot of where there's fast fashion is sewn together or whatever at the very initial level. All the audit said this is fine. No one actually went into the building and checked. Actually, all the exits were blocked with packages and things. So when there was a fire, thousands of people died, even though the audit hadn't even picked that up. Why? Because they weren't looking at the things from the kind of workers' perspective. So I think those are the developments. And I think also the final area I want to flag, maybe because it's an area of interest to me, is the finance sector, that they're beginning to realize that more and more, particularly younger investors, younger people, are aware of issues. Is this sustainable, what I'm buying or looking at? I want my investment actually to be an investment for good, not just an investment for money. And I think those things will put pressure on investors, who will then put pressure on the companies. That's off the top of my head, some of these ideas. Hopefully that gives you some kind of sense to where this is developing at a surprising rate.
Thank you so much.
Thanks, Alexandra.
We may have time for one more question, if anyone else has something. David.
Thank you. First, I'd like to say that it's been a very informative dialogue, and I think I've learned quite a lot in terms of the place of human rights and business. And actually, last year I also interacted with this in a competition that I did. It was majorly anchored on international criminal law, but there are certain aspects of businesses coming in and contributing to the violation of human rights. I think I've gathered quite a lot in terms of how wide the scope is. And maybe a question that I would first ask is that, being that now there is no binding, or rather solid legal document that would bind states in terms of how they act in the sphere of human rights. So what would be some of the mechanisms that would be used to now hold these states capable? And also, just to now maybe look at it in terms of where it's headed, what are some of the possible areas of research based on the current work that the UN has done in terms of interacting with the space, the place of business in international human rights law?
Yeah, there's cleverly two questions in one there. Let me start with your question about there's no binding legal document on states. That's correct. There's not a treaty as such. There's the OECD guidelines, which governments which are part of the OECD, which include USA, Canada, all the European countries, Australia, New Zealand, etc. They should be complying with that. Of course, they don't. But I think we have to always be careful about, do we always need a binding treaty, when the reality is, sadly enough, most states don't comply with their international treaty obligations. And there was a big debate about whether or not UN Guiding Principles were enough, because they would, and I showed the example, have sort of flowed into legislation and business practice. Do we always need a treaty? I think a treaty can help, but it can also hinder. A treaty which is not strong enough and which perhaps becomes one where nobody then complies with ends up possibly making the situation worse rather than better. But if there is a treaty which governments are prepared to accept and then apply, it would be a lot better. That's always the difficulty. I mean, we all know of I started with the Convention Against Torture. Sadly enough, torture still goes on, even if there is a binding legal treaty. The difference is you can say this is illegal rather than just this is not good. And I think that can make a difference. And also it can make a difference is like, listen, you ratified this treaty. We're saying you aren't complying with your obligations rather than we just don't like what you do. So I think it can make a difference, a binding document like that. we're not there yet, and I think we'll be away from that. In terms of research, we are never short for research ideas, unfortunately, particularly when you think how recently we're talking about, only 15 years really of the guiding principles. One area which I think is quite interesting is we did some research a few years ago on what happens picking up Professor Crane's comment. What happens in a conflict? What are businesses meant to do? And their working group came up with the idea of heightened human rights due diligence, that a company needs to do more than just think what are the risks to the rights holder. They need to recognize by them being in that conflict, simply selling or whatever goods, they change that conflict. And therefore they have to be aware not only of the rights impact, but of their impact by being there on those on the ground and elsewhere affected by that. And I think that's the kind of area that jurists can pick up, being aware of the businesses in that conflict, in the crisis, that they are also have a particular extra responsibility rather than just simply, okay, they need to do ordinary human rights due diligence. I also think there are other sectors. I mentioned before to Alexandra about the finance sector, where there's a lot of pressure that they should invest, for example, in defence at a time when there's a lot of issues about defence. Is that the right way forward? I don't know the answer to that, but I think that there are definitely some sectors that could do with a lot more thinking on this, which I think would be quite helpful to kind of explore. In terms of research, I think almost any area that you could think of could be a business and human rights issue. Almost any sector. I mean, I'll take it one example, the recruitment sector. How much are they recruiting, but also then taking fees and holding passports and things like that. So that I think there's lots of different areas. And of course, whatever area that you're interested in, I think you'll find there's a business and human rights issue.
Thank you. Thank you.
All right. Well, I hope you will all join me in thanking Robert for this really interesting and informative talk. And then I also just wanted to take a second to plug our next webinar in the 30th anniversary series. 1 month from today, we will be joined by Richard Goldstone, a retired judge from the Constitutional Court of South Africa. So I hope to see you all at that session as well. Thank you, everyone.